For those of you who have joined, a very, very warm welcome. I hope you're all safe and well. For those of you who don't know me, my name is Roger Isaacs. I lead the forensic accounting team at Milstead Langdon. And I am delighted to welcome today our guest speakers from Greylist Trace. I'm sure that I'm not alone amongst forensic accountants, has been contacted periodically by clients who say that they want me to find out if there are any undisclosed bank accounts or money that's been squirreled away by parties to a divorce. And up until now, I've always had to say that I don't have any superpowers. I don't have any access to secret government databases, and I've got no way of answering that question.
Hi, sorry about that.
No, that's right.
It's Bob.
Well,
that's great, Roger, because Bob was doing the first session. I was going to have to be improvising very greatly if he didn't appear.
I'm only doing my introduction, so welcome, Bob. Although you're titled as Nigel, so you're both shown as Nigel, but I will do the introductions in a minute. Yeah. So as I was saying, as family practitioners will know only too well, for a long time, the Hildebrand case gave the authority that effectively the end justified the means. And if you could find out that there were hidden monies, no matter how nefariously your methods had been, you could get the court to admit those documents into evidence. But thanks to Lisa Chenguez and the Immerman case, all of that came to a close. And to my knowledge, nobody has yet ever used a search and seizure order in family proceedings. It's extraordinary to think that anybody would have ever thought that was a practical thing to do. And therefore, it is really difficult for people who have strong suspicions that there are undisclosed assets to do anything about them. But all of that is about to change, as you will hear shortly, and as Bob and Nigel will explain. Greylist Trace have come up with a way that breaks that catch-22 and allows you to present evidence of the existence of bank statements that can then unlock further evidence through the disclosure process. And once they've spoken, I'm going to hand over to one of my partners, Simon Rowe, who's going to talk a bit about court receiverships. I'll introduce him in a few minutes, and then hopefully we'll have some time for some questions at the end. I'm going to try and keep an eye on the question and answer bar and the chat bar. So if you do have any questions as we go along, feel free to put them in, although we may not deal with them until towards the end. So without further ado, let me hand over to Nigel and Bob. Bob Duffield is one of the founders of Greylist Trace. He began life working on a program that I'm certainly old enough to remember, That's Life, as an investigative journalist. I'll let him tell you the story by which he got from there to where he is today. So over to you, Bob.
Roger, thank you so much, and apologies for being slightly late. Here I am. Let me give you some context about who we are. I met Nigel 21 years ago, I think, 1999. If you look closely, you'll see he's a Welsh accountant, but a Welsh accountant of great genius. Amazingly, he managed to raise some money so we could launch a boutique corporate intelligence company called Y Limited. Unusually perhaps for me, I came from, as Roger said, from a journalistic background. A lot of people in the corporate intelligence or investigation space tend to be ex-spooks or army or people like that. But no, I came into this world as an investigative journalist. I used to produce a program which people over 40 will remember, called Rough Justice and Trial and Error. And essentially these were programs which tested the hypothesis of innocence for people serving life sentences. And we managed to get quite a few people out of jail, about 12, over the years. Then I found myself in my mid-40s, and the investigations had kind of closed down in the BBC, and I thought, what am I going to do? And amazingly, I managed to get a bit of a break to join this world, which we're going to tell you about. Nigel and I, we teamed up. He raised some money. Y Limited was formed in London. But perhaps the key element for Y Limited was that I met this amazing guy called John Rawson, who's the sort of the invisible partner you won't see today. He spends like 24/7 up in Sheffield doing the work, the real work. But when we were doing Y Limited, we had the sort of things that you do as investigators. We had sort of due diligence operations, a bit of fraud investigation. But we also were looking at asset tracing. And this is very, very tricky. It's very hard to do asset tracing. You climb endless mountains to find that the money's gone, the bank accounts that you find or have found legally are emptied. And so it was a real problem. So I remember saying to John, 2013, I think it was, wasn't it, Nigel? Around that time.
Roughly, Bob. Yeah.
And basically, I said to him, look, John, if you could find a legal way of establishing where people are hiding money in the banking system, we are literally going to clean up. And it was said almost a throwaway request, really. I didn't have any notion that he'd ever be able to do this. And then he came back about 6 months later in his broad Yorkshire accent and said, you know, Bobby, I think I cracked it. And so this is the story of the Greylist algorithm. It was called Greylist more recently. We actually evolved the technology in Y Limited from 2013 onwards. And basically, I think we've been in business now for about 18 months. We raised, again, thanks to Nigel, we raised some more money to launch the Greylist algorithm as a separate business. And basically, we're here now to sort of establish how this actually works for you people in the divorce world. So just bear with me. I'm just trying to find what's happened to it. It will show up any minute now. Oh, God. Sorry. Basically, we really think that this is an absolutely bespoke tool for divorce lawyers, because as Roger said, that what happens is in divorce, I mean, you know it more than we do. I'm not a divorce lawyer, but marital disputes create a lot of heat, there's a lot of dispute, and there's a lot of stress, and they go to you guys to try and sort it all out. And emotions run high. And basically, it means often it always boils down to something like, how much money is there? Where is it, crucially? And I think the trouble is with a lot of people in the divorce space, when they're going through marital disputes, they genuinely think that they might actually play fast and loose with the rule book and think, actually, if I don't disclose bank accounts, then no one's ever going to find out. And so this is really where we think, because we're obviously making quite a lot of inroads into asset tracing generally, but we generally think that this is a fantastic opportunity for you guys. So, as I say, failing marriages bring disorder, stress, and insecurity in about equal measure. And at the end of the day, it boils down to money. Claim and counterclaim generate a great deal of heat, and emotions run high, and effective communications break down between parties. And the divorce courts exist to restore a sense of order, fairness, and justice, especially in the equitable division of marital assets. But even the most rational among us are tempted to play fast and loose with the legal rule book. All too often, justice is denied because individuals fail fully to disclose their assets to the courts. And some go to great lengths to hide their money by opening secret bank accounts, confident that these will never be recovered. Confident, that is, until Greylist arrived on the scene. As you've heard, the Greylist algorithm is asset tracing intelligence software invented to tackle corruption, economic crime, and the ubiquitous practice of financial non-disclosure. So what precisely is Greylist and how does it work? The Greylist algorithm can legally find hidden accounts in the global banking system. Our clients supply us with the email addresses of a person of interest, a defendant, or party to a divorce. Now, we load these email addresses as digital code into the Greylist algorithm, which we dispatch to every bank in the world. Now, in essence, the spam filters protecting a bank's email servers are tested for prior contact with the target email address. Now, a positive connection is where a bank has whitelisted the target's email address. Now, there is a 98% probability that a whitelisted email address has been used to register an account at that bank. Thus, every Greylist out report is essentially a list of banks where a target has likely opened an account. And in each case, we specify the name, country, branch, and address. And in just 6 weeks, Greylist reduces the vast set of 220,000 possible banks, pretty much every bank in the world, to a handful of highly probable locations. Now, legal teams then can use our reports to apply through the courts for disclosure and or freezing orders. However, the biggest and most immediate impact on a legal case, especially a divorce, is leverage. In one fell swoop, a Greylist report lists all the hidden accounts opened by a party. Suddenly, discretion is the better part of valor, and better by far to settle than risk being caught in a lie. Now, legal counsel agree that Greylist is legal. We do not breach computer misuse, data protection, or banking secrecy laws. We're neither phishing nor spoofing, and we are GDPR compliant. Greylist is a cost-effective early intervention for any asset tracing investigation, but it is especially useful in divorce cases. As the word spreads, we are being approached by asset recovery teams all over the world, especially litigators, arbitrators, forensic accountants, and increasingly divorce lawyers. Now, we thought the best way to give you a real sense of the scope of the algorithm and its reach would be to run through a few case histories, suitably anonymized, of course. So Nigel, what have you got for us?
Okay, thanks, Bob. Good introduction. So let me do a couple of cases related to divorces, but as Bob has said, of course, we can be used in all sorts of asset tracing situations. So in May of last year, we were contacted by a wife involved in a US divorce case, and I saw a question coming up about how global we are. We are indeed truly global. And she'd seen us present at an Offshore Alert webinar last May. Now, this lady had hired a Denver-based investigator in his 70s to identify accounts related to her Japanese-American husband. And the investigator had come back with a list of 10 banks spread around the world, including a UK internet bank, a Singapore internet bank, quite a collection. But he was extremely woolly as to where exactly this information came from. And two of the banks, however, were listed were in Jersey. So the wife spent quite a lot of time and quite a lot of money getting a disclosure order. And surprise, surprise, the bank denied holding any accounts of the husband. So what we did here was a limited application of Greylist. We didn't do a global search, as I'll describe in the next example. We can verify an individual bank in a confirmatory way. So we Greylisted just the 10 banks she'd been given. And at her request, we added 2 banks in Vietnam. So we subdivided our database of 220,000 down to 12. And in a week, we got our results. And we came up with 4 positive confirmations. 2 banks in Hong Kong, 2 in Japan. But crucially, neither of the banks in Jersey. So maybe if she'd used us first, she'd have saved a bit of time and money. So we prepared a Greylist report. We have a standard Greylist report we can share with you. And when it's going to court or in being involved in negotiations, we can add some additional boilerplate about Greylist subject to the limits of RP and how IP and how it works. And I swore an affidavit or a statement under penalty of perjury in California. So it was used in a California court for an application for letters rogatory, which I guess means a lot to you guys and girls, doesn't mean so much to me. And interestingly, the husband's lawyers opposed the application. So I wonder why. That's almost like admitting guilt before it happens, I guess. Anyway, the judge dismissed the opposition. He granted the letters rogatory, and disclosure is now going on in those 2 Far East territories. So that's an example of how quite cost efficiently, quite quickly, Greylist can be deployed. Let's go on to another case. And in August of last year, we're asked to investigate 3 email addresses relating to a businessman who was involved in a somewhat messy divorce case in Australia. And we found a bunch of banks, in this case, 7 or 8 of them. And so prior to the court date, The wife's lawyer presented the banks discovered by Greylist that hadn't been previously disclosed. And within 24 hours, this was quite amazing, the husband presented an affidavit declaring quite categorically that he didn't have accounts in any of the banks we'd identified. And simultaneously, this was quite an aggressive bunch here, the wife's legal team had contacted the banks identified, stating they believed they had good reason to believe that the husband held accounts with them. And then the client got swift replies on a goodwill basis from one of the banks. I can't disclose the name of the bank. All I can say, it's a global bank, and I'm going to call it ABCD Bank. It's one we come across quite a lot. And both ABCD Bank in the UK and in Australia, in separate communications, stated they didn't have any accounts at all related to the husband. And so this is where Greylist adds another dimension to disclosure, by the way. The wife's lawyers went back because a name, a date of birth is an identifier, an email address is a unique identifier. So the wife's lawyers went back to the banks asking for more details. For example, do you recognize this email address? And has it been registered with you for the purpose of opening an account? And ABCD Bank in the UK in particular stated very clearly the husband didn't have accounts and they didn't recognize the email address or email addresses. So this had us in a bit of a quandary for about 48 hours, with even our client's lawyer saying, Greylist, are you right? You know, have you got this wrong? But however, at the 11th hour, just before the hearing, evidence emerged that the husband, in fact, did have an account in the UK, in London, with the bank. It was in his personal name. He'd had it for 5 years, and rather conveniently, there was £500,000 in it. So that was a rather good result. And so I guess the moral of the story is that even the mainstream banks and some of the smaller ones, I guess, can't be relied upon to disclose banking relationships. Some of them, I think, systematically organize themselves to be quite obstructive in this area. So what you need is almost certainly a very strong and very effective court order. So let's throw the ball back to you, Bob.
Yes, well, even the very early days of Greylist, I picked up a very high-profile divorce case from an investigator working out of Geneva, and it involved an aristocratic Italian family, and there was a lot of gossip in the continental yellow press about this. And we were simply given 2 email addresses belonging to the husband, and we found a total, I kid you not, of 14 banks: Switzerland, Italy, Germany, Brazil, and USA. What we call almost the full house. Anyway, on being shown a copy of our output report, we were told that the color drained from the husband's face and he settled immediately. And so in just 6 weeks, our intervention immediately ended a very long and tortuous legal battle. Now, just moving slightly away from... Sorry?
On that 6-week point, we've just had a question, which, as you mentioned it again, what's the reason for the 6-week time frame? And can you get a shorter?
Well, yeah, well, Nigel, you answer that.
I think it's purely because, well, a number of reasons, but one of which is that the internet is rather like the weather. And I think particularly in the last year with COVID, it's the internet has been, with power outages all over the place, extremely difficult to navigate. We're effectively going around the world to 220 countries, checking 220,000 banks with email addresses. And for each email address, we send out about 1 million communications. And you probably noticed the internet speed can be rather variable. I'm sitting in Kew at the moment in London, and my internet is, first of all, lousy and varies second by second. And what the Greylist algorithm is doing is measuring the speed of the internet with our piece of code in milliseconds. And so it's a process that is quite complex, quite difficult. And so we basically almost like send a train around the world, picking off country by country. And so we do it steadily. And because of outages, bank systems being down, We get a lot of situations where we have to review the data, check it for credibility, and quite often do it again. The other reason, I guess, would be that we sit with our servers and our data centers up in Sheffield. And if we're doing a case, the results are due today. We're testing 91 email addresses on a global basis for a very big US law firm. And if we did them all on one day, we'd be sending out 91 million communications. And I think our data center might actually ask, you know, what exactly are you up to sending this many details in one day? The answer is, however, though, if it wasn't for COVID, we started 2020 with a 6-week time scale. We expected it now to be down to 2 weeks. But such has been the impact of COVID with people on Zooms, webinars, on Netflix and everything else, and such is the variability that we're having to run 2 or 3 times as hard just to maintain our 5 to 6 week period. But as I explained in my first case study, for a limited number of banks, if we did it for a continent or a couple of countries, we can still get results in 1 to 2 weeks.
Yeah.
Thanks, Nigel. Bob, sorry, I interrupted.
Well, I was no, it's fine. I mean, I just wanted to give you a sense that obviously we are very keen to get into to do more divorce work for you, especially given Roger's great introduction. I think there's a need for a new kind of fifth cavalry coming over the hill, and we'd like to be that. But just to give you a sense of the power of settlement, legal settlement. I mean, as lawyers, you will all know that most cases are settled anyway, I guess. But it really is the power of a Graylist report. I'll give you a good example. We had a nice to a conference in Amsterdam. We met some very nice law firm, some lawyers who coincidentally live in Cheltenham, where I am today. They also have a London office, and they basically came to us and said, "Look, we've got this case. It's last chance bar, really. Our clients are running out of money. They've been the defendants are battling away, saying that there's no money. All the money's gone. We've spent the money." And it's true that all disclosed. And so they said, well, what can you do in 2 weeks? And we said, well, okay, we'll do a grey list of 13 countries. Basically, you might call the standard UK. It's a UK case, so UK tax havens, so the Channel Islands, Gibraltar, some in the BVI, and I think we threw in Switzerland for good measure. So 13 countries. And we went straight. We were given, and they had obviously there were judgments against all of these 3 individuals, and they claimed they hadn't disclosed anything. So basically, we then turned this round in 2 weeks, and in just 2 weeks we found 15 new banks in 8 of those 13 countries. And what was also interesting was that there were some banks where all 3 had accounts. There were some banks where pairs of the 3 had accounts. And so it was absolutely incredible. There's no way they could deny that these accounts were, they existed. And so of a £12 million claim, suddenly they found 8 million to pay our clients. And I think we actually, even because they were short of money, I think we even did a deal, didn't we, Nigel? We said we'll take a bit of back end on this because we were keen to show our wares, as it were, and to do the right thing.
Bob, what do you charge is one of the questions that's come out, which I knew we would be asked.
Nigel, you're the financial man?
Yeah, I'm the numbers man, apparently. It works out, we charge per email address. And so it's a question of assembling the set of email addresses related to the target and maybe some conciliary. And we also have a very good email search unit that can supplement situations where we've even had clients chasing billions who don't even have a single email address of their target. So it comes out at round about £3,000 per email address for a global search. It would be a bit less if we did it country by country or regionally, but about £3,000 per email address. And on average, we tend to find a couple of banks per email address we search. We also have another model, which Bob invented, where we charge £1,000 per email address and then £1,000 for each bank we find. So to us, it's a bit of a nil-sum game, knowing on how many bank accounts we normally find, but it then lowers the upfront cost. And I think in a divorce case, particularly, for example, the the party seeking a divorce is normally short of funds. So to that extent, that's roughly the cost. But as Bob said, we will in some cases look to take a deferred fee or a back-end percentage, and that could well work well in divorces as well, because unlike some cases that go on for 10 or 20 years, I guess most divorces get settled in about 12 months. But I think you're going to say, Bob, that we took a deferred fee on a success basis and we got it 2 weeks later. So that must be some sort of a world record, I think.
One of the other questions that's been asked, when you do one of these searches, a Greylist search for a divorce, do you have to tell the person about whom you're searching that you're doing it? Do they know that the report's being run?
No, absolutely not. The banks don't know it. They don't know it. Basically, if you sign up for a Greylist, and you sign our documentation, in GDPR terms, our client is the data controller, we're the data processor, and our client has to confirm to us that they've legally obtained the email address or addresses, and that they have a legal right to ask us to process, like in any investigation. So, for example, if a journalist rings up and says, can you Greylist Taylor Swift to see if she's got any accounts in the Caribbean or whatever, so I can write a sensational article? The answer is no. Maybe a true investigative journalist who is investigating a real case maybe is a different matter. So we don't go fishing with an F as opposed to a PH in that sense. So there has to be a legal basis. And I guess you'd have to tell me, but in a divorce where one is looking at disclosure and believing there is lack of disclosure, there may be, enough legal grounds to say one should investigate. And bear in mind, we're doing what any other investigation firm would do, except all we use is an email address. We don't take a mass of personal data and run around the world trying to find information.
And we aren't following anyone. All our work happens in cyberspace.
That's right. So anyway, in Bob's case, we've got one more case study and then we finished, Roger, unless you've got a few more questions to throw in right now.
The case study.
Okay, let's do the final case study. We'll let you off the hook here. So what Bob has been describing is effectively our Greylist Gold and Silver product, which is a global or regional search done against our entire database or a segment of our database. We have another product, we have two others actually. We have something called Greylist Red, which is a KYC AML product where we can test an individual against sanctioned banks and sanctioned organizations, which is very good for client onboarding. But we have a product also that's got quite a lot of traction called Graylist Connect. And that comes down to the very origin of Greylist, which is that we can take any two email addresses anywhere in the world and quite legally tell you if they've communicated one way or both ways. And this is very good in conspiracy cases or where people claim not to be connected. And so there's an example, the first case of 2020 we did actually. So in the last quarter of 2019, we did two Greylist Gold assignments for a major global investigation firm. One related to the ex-prime minister of a Far East country, the other and his family. The other related to three prominent businessmen in an adjacent country. And we ran a lot of email addresses. We found a lot of banks. And again, this goes to the fact, can we search globally? The answer, yes. We often get banks in China, in Hong Kong, in the Far East, because I guess it's a global banking system and the internet is global and the English language predominates. So to that extent, there is nothing that prevents us finding accounts anywhere in the world. So on the first Monday of last year, 2020, I was sitting at my desk, if you believe I have a desk, wondering when the first, actually it's covered in stuff when I sit in an armchair with my laptop, or I put my record albums on the wall and let people guess who they belong to, stuff like that. Anyway, I was sitting there and then I had my answer at 9:37 a.m. on that Monday when our client came back to us and said, well, thanks for the two Greylist Golds you've done, but now we want some more. And they said, and we don't have to know this because apart from our onboarding, we don't need to know the granular detail of the case being run. We just need email addresses. And so they categorized the politician in his family as group A, the businessman as group B, and then they came up with a group C. It was 3 individuals who I guess are financiers or deal fixers, primarily look like Brits. And when I looked at the surnames, there appeared to be an Englishman, a Scotsman, and an Irishman. And that's no joke. So what the client wanted us to do is to test for 2-way communication between these 3 groups. In other words, the politicians and the businessmen, the politicians and the deal fixers, and the businessmen and the deal fixers. So a total of 248 pairs of email addresses. So quite a piece of work. So 4 weeks later, we had our answer. We had 26 pairs of connections. So 11% of the total. And what the results showed were 2 very interesting things. Firstly, the ex-prime minister and the most prominent businessman had denied knowing each other, even in court. But we managed to fix 2 email addresses of the ex-prime minister against 3 email addresses of the most prominent businessman, and we got 6 positive 2-way communications. So that made their communication undeniable, also proving that they had lied to the court, basically. So that was extremely useful leverage information. And secondly, the client didn't know which of the 3 deal fixers. I could tell you the nationality at the end if you want to, but maybe I'll keep my powder dry. Which of the deal fixers or which combination had been most active in whatever transaction had come to pass. And what we found, we had 9 2-way connections involving the deal fixers. For one of them, there were no connections. One of them, there was 1. But one of them, there were 8 connections spanning both the businessman and the politician. So in terms of deploying resource, the client decided that, this is probably the obvious one to start with. And Bob and I, and I'm just about to finish, Bob and I understood fully the massive impact that the results had on the case when we met 2 of the client's people in the bar in the last acid tracing conference we managed to go to physically, which was the end of February last year in Dublin. And they basically told us that after having had a few drinks, so we believe they were being honest, that this had blown the case wide open. And I know that litigation is still ongoing, and we've done even one more grey list in relation to the same case. So that just shows you the power of a connect.
Nigel, I think that touches on a question that has been asked, which I think is absolutely key. And I know you're working with law enforcement agencies and with HMRC. And the question is, has the legality of this been tested in an English court, in particular a divorce court? I don't think it has been tested in a divorce court. But Liz asks, I'm conscious of the fact that if this falls foul of our laws, it's the lawyer who commissions the search who's criminally liable. Do you take instructions directly from clients, or does it have to be the lawyer that instructs you?
It works both ways. We get instructed directly by clients, by lawyers, by both, sometimes by liquidators, all sorts of people.
I think it's fair to say it hasn't yet been tested in the courts, has it?
I mean, it got through the California court, it's gone through the Italian courts, it's gone through the Swiss courts. I just saw an affidavit a couple of days ago for Grand Cayman, where it's going to be to support a Norwich Pharmacal application. And so that, I think, will be happening this week. But we do have legal opinion from Barrister and QC in the UK. We have legal opinion at state and federal level in the US that we are legal. We've had our tires kicked by the general counsel of several big investigation firms. And Bob, I think we've gone through technical and legal compliance with HMRC Special Investigations Unit. And actually, a couple of weeks ago, we were asked for a proposal by the IRS. So over the period we've been now visible, no one has challenged the technology. And it's going through an increasing number of courts. But I understand, very fair point.
That's because we neither in our deployment, we neither leave and deposit information or subtract information. Essentially, the algorithms what algorithms do. based on a timing differential, it makes a calculation. We are not in any way dealing with data here. It's not a totally dataless free system.
Yeah, I mean, we never get to a bank server. So in terms of computer misuse for a number of reasons, in terms of passing off, phishing, fraudulent misrepresentation, GDPR, so we are stopped entirely at the spam filter level, and the communication we send, we don't pretend to be the person. We just take the email address, digitize it, send an job is to test email communication. So there's no content, so the Can Spam Act in the US doesn't apply, etc. So as Bob said, it's the statistical inference at a very high probability.
Well, I can round this up finally when John, that I've given the Yorkshire accent before. I said to John, okay, what do you mean? I said, because right at the early days, I said, well, we will be challenged in court. I suspect we aren't being challenged because people can't see any problem with it. But so reinforcing what I said earlier, we do get settlements. So as soon as people see all the banks listed in one document, then settlement is really on the card. So I really think you should give it a whirl.
We've got lots of questions coming in, but I'm conscious of time. So I'm going to hand over to Simon.
Yes.
Needs to have some airtime, and hopefully we'll have a few minutes towards the end to come back and answer some of the questions that we haven't got around to.
Well, thanks very much.
Simon is, as I say, one of my partners, and he is going to explain about how once you, at the other end of the divorce proceedings, once you've got an order, if parties aren't complying, how you can use receivership to recover assets. Simon.
Thanks, Roger. Morning, everybody. I'm far less up to the minute and high tech as Nigel and Bob. In fact, I wanted to check just how far I could go back. I couldn't find the first instance of a court-appointed receiver, but even the most recent bit of legislation supporting a court-appointed receiver's application was 1981, which I originally didn't think was that long ago until I realised it was now 40 years ago, which just really. I'm a partner at Milstead Langdon, as Roger says. I run our insolvency and intervention team. So what I do is run other people's businesses for them and take away their assets. And one particular instance in which we do that is court-appointed receivership. So I just wanted to talk about the scenario where you've used Nigel and Bob's clever tool, you've found all the money, you've got your final order. Husband, if it's okay with everybody, I am going to say husband as the non-complying spouse here. It could be a wife, it never is, but it could be. So I'm not being sexist. This is just 100% accurate based on the data of the cases I've dealt with. It's just us blokes, I'm afraid. Husband has been told that he's got to make payments. Ex-wife is happy, everybody's happy, you've closed the file, you've gone away, wait for the money to come in. And it doesn't. And you go back to court and the judge says very sternly, you've got to pay this money, and it doesn't. And this continues and everybody gets crosser and everybody gets angrier and costs increase. But actually, the civil law isn't very good at managing non-compliance. There are only so many levers that the court can pull. In fact, it's not dissimilar to me trying to wrangle my 2-year-old. If he just decides that he's not going to do that, there aren't actually very many things that you can do to persuade him. In fact, it boils down to one of two things. You can either find him in contempt, not my son, the husband, find him in contempt and take away his liberty, or you can start taking away other things. And it's those other things where the court-appointed receivership comes in. It is kind of an ultimate sanction, and it is a very draconian step. So judges are not want to grant these sort of orders until all other avenues have been explored, and basically until the judge is sufficiently knocked off with this individual that he's willing to bash him over the head with a receiver. as I say, for those of you that like the sections and the statutes, it's section 37 of the Senior Courts Act 1981 that gives the power. It's all of about 12 words long. It's really helpful because it gives you the power to appoint a court-appointed receiver. It's really unhelpful because it tells you nothing about how that court-appointed receiver is supposed to act, what powers they have, nothing at all. And therefore, it's really, really crucial that when you're making an application for this order, that application includes everything that you might need. Because if something's missing, it means you've got to go back to court again, receive further powers or further authorization, include further assets. And all that does is increase cost and increase the likelihood that husband is going to do something with those assets or squirrel them away where somewhere only Nigel and Bob would be able to track them down again. So we need to make sure that first application includes everything it possibly can. And by the wonders of the internet, I'm hoping that in the chat there, you will have just received a link to a standard drafter. Because I'm always asked two things when talking to solicitors about these things. The first is, have you got a precedent I can use? Now, I'm not LexisNexis. Okay, this is the one that I provide in those scenarios. You guys are better lawyers. Well, you are lawyers, which is more than I am. So I'm sure you can finesse it, but it at least gives you a starting point. The second question I'm often asked is how you spell Rowe. So I've included my name in the appointment section of that draft. But by all means, put somebody else's in if you need to. Can't think why, but just in case. Don't bother reading it now, but by all means have a flick through it later. But I just want to pick up a couple of points in there. The first is think big, okay? That often the deferred consideration is the bit that's outstanding. And often the reason why it's deferred is because it relates to funds in the husband's business, his privately owned business, and the courts accept that you can't just, realize that cash straight away, and so they defer the payment. But just because the payments that you're missing are in relation to that deferred element doesn't mean that that's the only asset that you can appoint a receiver over. You can ask the court to appoint a receiver over any assets that didn't exist at the time that order was made, assets that didn't exist at the time of the divorce. It doesn't matter. Any assets that are within the husband's estate at the time that the receivership order is made can be captured by that order. And so include everything, quite literally the kitchen sink and all, because that private limited company, I'll come back to this in a minute, is not necessarily the best lever that we've got. And all of this, much like what we were just hearing about, is about psychology, and it's about leverage, and it's about beating the guy over the head until he realizes that this isn't going away and it's going to happen. And therefore, the sale of his yacht, his Ferrari, his prized possession, whatever it might be, his signed Manchester United football top, whatever it is that is most important to this individual, the fact that a receiver is going to get appointed over that and is going to sell it has a far greater influence on that individual to get their checkbook out and write the check that needs writing than actually the machinations of selling a private limited company. It's about pulling the levers, and it's about persuading the individual that actually it's not that they can't pay, it's that they won't pay. And we need to change that won't pay into I will pay, because I want to get Simon out of my life. And if I write a check, he'll leave me alone. And that's not just because of my personality. The reality is often I don't even need to be appointed. The mere threat of me in somebody's life is sufficient to make them want to part with wadges of cash. So never threaten anything that you're not prepared to go ahead with. But that threat is often enough to bring sensible people, I mean that in the loosest possible sense, but sensible people to the table. So do think about what assets are there. Do think about the yacht, the car. Foreign houses are always good. So don't limit yourself to the UK jurisdiction. You can appoint a receiver over assets anywhere worldwide. So we've dealt with houses in France and Spain and yachts down in the Mediterranean. So do think about all of those things. It is harder to realise those assets in overseas jurisdictions, and Lord knows Brexit doesn't help, but I'm not going to get into that. But it is possible. And also, again, it has a psychological impact. I was asked to provide some advice on a matter where we knew there were significant assets in the UAE. And I was asked whether we can go after those assets, because it was clear that the other side thought that, well, they're safe over there. That's fine. The answer is yes, we can. We need to go to a local court in that jurisdiction and get our order recognised. But actually, again, the mere step of them seeing that we're going to that court, we're getting that order recognised, is enough to bring it home that perhaps I'm not as clever as I thought I was. And they do always think that they've outsmarted the system and that they've thought of something that nobody's ever thought of before, because that tends to be the sort of psychology of these individuals. And when they start to see that actually the world doesn't work like that, and that foreign jurisdictions are willing to cooperate, it's again starts to bring things home to roost. So do include everything, because we'll have a crack at anything. And by and large, we'll have a crack at the thing that we think matters most to the individual at the other end, because it's not really, the receivership is not often about me selling enough assets to get you the money that your client deserves. It is about me pulling on the levers such that the money materializes as if by magic into your client's account or into your client's bank account. Private limited companies aren't off the cards. As I say, they are difficult assets to deal with just by their very nature. Often they're very heavily vested in that individual, especially the smaller ones, because if that individual isn't there, what's the value of that business? But there's still loads of fun and games we can have with that. So what the order I've just sent you says that the shares will vest in me as receiver. So we can then call a shareholders meeting and have a discussion about what dividends are going to be paid to me as shareholder from your business, sir. And to be honest, I hope we can come to some sort of reasonable understanding, because otherwise, as shareholder, I might have to appoint an alternative set of directors and remove the current set. Again, some of that might be bluster depending on the circumstances, but I never threaten anything I'm not prepared to go through with. But again, it brings home to the individual that this problem isn't going away, and they are just going to have to deal with it and have to face facts. Now, we had some questions about costs. So with Nigel and Bob, so it's only fair that I talk about that as well. Costs are borne by the errant spouse. So husband pays those costs. It's his fault, after all, that I've had to get involved. They do get charged as a first charge on any money that comes in, because quite frankly, if we didn't get paid, we wouldn't do this work. But it is an additional cost borne by him. So it's not borne by your client. In some circumstances where the asset base is particularly slight, we might ask for a small undertaking from your client, never the whole fee, but just something to cover sort of basic costs. But where we're confident in the asset base, then we won't even look for that. And we do insist that husband pays. I had a case, just a quick case study so that we've got some time left for questions. I had a case a couple of years ago where, again, husband was definitely one of those individuals who thought he was too clever for the English legal system. And instead of paying me the funds to be able to pass on to the wife, he got his friend to pay money to the wife to clear the debt in his name, thereby circumventing me and circumventing my first charge on the assets, because they weren't assets within the estate. Wife was very understanding and was willing to have a chat about the costs, which was very kind of her. But in the first instance, we pursued husband through the court, and I'm happy to say that husband paid up, because one should never leave an insolvency practitioner without paying them. We just don't take it very well. So on that friendly note, I'll hand back to Roger and leave some time for questions, hopefully.
Thank you, Simon. That was absolutely fantastic. So we have got some questions. I'm conscious that Hannah asked a question some time ago, which we didn't deal with at the time, but it's one I think for you, Bob. I'll read it out. In the case where ABCD Bank denied having bank accounts in the respondent's name, how did you find out that he did indeed hold this account? And was it through a third-party disclosure order? I don't know whether you got that involved in the legals, but can you shed any light?
Nigel did. This was Nigel's case.
I apologise.
Yeah, it wasn't through a third-party disclosure order. We hadn't got to that point yet, but it just transpired that someone found a piece of paper with a transfer from that particular account right at the death, and that pinned the account number. But clearly, all of this in the court was leading up to disclosure orders, if necessary. But this was at the very much the pre-disclosure point in time.
Yeah.
Thank you. And then Ashley Palmentary is asking exactly what is it that you get when you have when you receive a Graylist report? Well, I'll read out the question. Do you, as part of the service, help us analyse the results? For example, interpret the hits as high or highly probable as to the existence of an account which can be converted into a statement for an application to court?
Definitely, yeah.
Well, as Bob said, it's a list of banks, banks, branches, branch addresses. That's all it is. We, of course, put it in a glossy report with some disclosure, usually a map of the world, which we identify the countries as well. And then, as I said, we can add extra sections if it's going to go to court or in a negotiation to explain, as far as we can, the Graylist process and what happened. And then backing it up with a statement or affidavit as necessary about what is the total uniqueness of the Greylist algorithm. No one else in the world appears to be able to do this. We've talked to people at GCHQ and MI6 and the IRS and the global investigation companies. And if there was another equivalent, I guess we'd have heard about it over the 7-year period since we started doing this, which sort of means, and it sounds like a big claim, but it's true, that we are the only people who can tell you every bank connected to a person of interest. Any other investigator can just look in the foothills and over time maybe find more, but no one can guarantee you all of them. When it comes to have we found all the banks, and the banks we list, are they definitely, related to an account? As Bob said, we attest 98% probability and a bit more. When we give you a bank, there will be an account. It could be personal or corporate. We don't actually know the difference. Well, we could maybe with some more investment do it, but it could be a personal account or a corporate. Be asking the widest range of questions you can. Is there an individual account? Is the individual an officer, director, or signatory of any other account? And now, do you recognize this email address? Is it recorded in your system for account opening or correspondence purposes? And in terms of do we get all of the banks, we're not infallible. Nothing is perfect in this world. The database of banks changes hourly or daily, but we have 90x% of all the banks in the world. It's conceivable we could miss a bank because 98% is not 100. We try and avoid false positives, but it is a major advance in identifying where the money is likely to be. As Bob mentioned, what we establish if the email address has been whitelisted by the bank and the reason we believe that this communication we've proven almost always means an account is we don't just test communication with a bank in general, not the marketing department, the PR department. We focus specifically on communication with those hierarchies in the bank's email system relating to account management, account operation, and internet banking. And the only time we sometimes have a problem is if the target is widely known. So if it's someone who's been 40 years in the banking and investigation industry and then has gone bad, but as a result of their work has been in touch with almost every bank on the planet, you would sometimes find that person has communicated a lot with bank transactional departments, and occasionally we get more hits than probably we should. there'll be the genuine bank accounts and then maybe the greater communication. But in almost all cases, you know, the banks we list are the banks where the money is going to be, but we can't tell you the account number, we can't tell you what's in the account because that would be illegal. So we, in this case, are very much, you know, the white knight, I guess.
And we've got a question for Simon from Hannah. Do you ever use receivership where there's already an order for sale of an asset, such as a property, and the respondent's just frustrating it?
Yes. Yes, I mean, if you think about different types of receivership, LPA receivership, for example, Law of Property Act receivers, I mean, that's precisely what the process is for. You've got to bear in mind whether the court's going to grant the order. So there's one thing to say, can you apply for it in those circumstances? Definitely. You've got to make sure that the court is sufficiently convinced that husband, to continue that, husband is frustrating the sale. Rather than it just being a difficult market and COVID, you know, et cetera, et cetera. But so long as you can convince the judge that, look, this isn't going anywhere until we take X, Y, and Z out of the proceedings, then yes, that would be ideal. If the individual that's frustrating the sale is also in residence, though, we're going to have to think about possession proceedings as well, though, in that scenario. So you've got to get the judge really narked before he's likely to grant that order, I think is the only caveat I'd add to that.
Thank you, Simon. Well, I'm conscious that it's coming up to the hour, so I am hugely grateful to Nigel, to Bob and to Simon. Judging by the number of questions we've had and the number of people that signed up, this is clearly captured people's imagination. I apologize if we haven't got around to answering your question. We'll try and deal with that afterwards on an individual basis. But in the meantime, feel free. I should disclose, I've got no financial interest in Graylist. I just came across them by accident and thought that this was probably going to have quite a revolutionary effect on undisclosed bank accounts. So I will be very happy to provide contact details if you want to talk to Graylist directly. But in the meantime, I hope you all have a safe and enjoyable rest of your day. Thank you ever so much, both to the panelists, for all our delegates for attending. And I hope to speak to you and perhaps maybe one day even see you all again very soon. All the best.
Bob will buy everyone a drink when he sees you all. That's his normal boast on these things.
Terrific. I look forward to that. Okay.
Thank you very much, Roger.
Thank you.
Thank you.
Bye-bye.
Bye-bye.